Hello, and welcome to this panel, which is looking at how privacy overlaps and is relevant to other laws that are relevant for the digital sector, in particular, competition laws and consumer protection. I'm Nicholas Hirst. I'm a reporter with Mlex in Brussels, write mostly about competition policy. We've got a stellar panel to discuss a whole series of questions on this issue. So, firstly, how does privacy fit in to antitrust law, consumer protection law? If we properly enforced competition laws and consumer protection laws, would we plug some of the gaps in privacy enforcement? And can properly enforcing privacy help ensure fair markets and that consumers are properly protected? We're also going to look at more institutional questions. To what extent do regulators at the moment cooperate and work together on these questions? Can they do so legally? Can they do so practically? The EDPS, our host today, back in, I think, back in 2016 or so, set up the Digital Clearinghouse project specifically to help regulators meet and cooperate. And then we're going to end the panel with a broader question, which is, when you're trying to grapple with the tech giants, with companies that are that large and that powerful, do you really need actually a single digital regulator that can have a whole hand of different cards and decide which ones to use in a particular instance, whether it's consumer protection laws or privacy or competition? I'll first briefly introduce the panel and then we'll kick off. So on my left is Cristina Caffarra, a top antitrust advisor to businesses, currently senior consultant at Charles River Associates, and really someone in the antitrust community that has done so much to get people to think about how privacy is relevant to competition law. On my far left is Olivier Silva, who's just flown in from Washington, so thank you very much. He's a law professor, but currently working as a senior advisor at the Federal Trade Commission. And then online, on the left is Angelene Falk, who's Australia's Privacy Commissioner. She heads up the Office of the Australian Information Commissioner. And then on the right-hand side, from where I'm sitting, is Alexandre Streel, who's a professor of law at the University of Namur, and who's managed the EDPS's project, the Digital Clearinghouse, for some years, and will be able to give us some insights about that. So without any further ado, I think we can kick off. I think, Cristina, it'd be good if you could set the scene. The traditional thinking is that privacy regulators do privacy, antitrust regulators do antitrust. What's wrong with that thinking?
Thank you so much, Nicholas, and thank you to the organizers for inviting me here. I must say it is an unusual experience because when I go to conferences, I know everybody. And it is telling and interesting that at this event, I know such few people because this is the privacy community. And the antitrust community isn't here. Where are they? Why aren't they here? And this is really very much, I think, in keep with the spirit of what we're saying. So disclosure first, because I'm religious about these practices. I think anyone from the private sector needs to say who they have, what they're working for. I have worked adverse to Google and Facebook for a number of clients, including governments and agencies. I have done in the past 3 years work for Amazon, Apple, Microsoft, Uber, Netflix, and I think I'll stop there. So the reality is, as I said, I come from the antitrust world, which is the world in which decisions are made that allow this creation of these enormous amounts of market power through mergers. And then exposed one is trying to deal with that enormous amount of market power when the market powers run away with everything with antitrust investigation. And we had a number of them in Europe. The unsettling reality is that notwithstanding the good intentions and efforts, these investigations haven't really delivered what one was hoping they would deliver. And the reality is that when you look at particularly at mergers, enormous amounts of market power are being created because no deal is actually blocked effectively in this space. There are 1,000 mergers that have been counted, more or less, acquisition done by the largest digital companies over the last 10, 15 years. None was blocked, only just actually Giphy was blocked in the UK recently, acquisition by Facebook, only a handful vetted. When in fact, the real motivation for many of these deals has been precisely to acquire the ability to harvest, the ability to exploit data, and then leverage that data asset into adjacent markets and cascading power into other markets. And we have countless examples where we have not been able to spot it and we have not intervened. Google DoubleClick, the various Facebook acquisitions, and so on. That's history. And this matters because once you create this enormous amount of market power, the reality is that we don't seem to be very effective at controlling this market power and the exploitation of data that is associated with it through antitrust investigations. And then there is this problem, which is persistent. You have a serious market power crisis in the world today, and you have a data protection crisis. And these two are certainly reinforcing one another, because it is the case that it is the enormous amount of market power that's accumulated that allows the certain players to effectively disregard data protection at scale, and simultaneously it is the disregarding of data protection that allows the market power to be reinforced and extended and preserved and maintained. So I feel incredibly strongly that when you think about the two things and how they actually reinforce one another, we need an integrated approach. What are we doing? Because the insights that come from the data protection, from the privacy community, from the data experts are essential for the analysis, the diagnosis, and the prediction of how market power can be created, wielded, and leveraged. Let me say what I'm not saying, because when I say this, there is always a bit of discomfort in the privacy community, because the data protection people think I'm saying that we need to pursue data protection goals through antitrust. No. I'm not saying that. I'm not saying that one pursues data protection through the antitrust tool. They're separate things, but I'm saying that antitrust enforcement needs to benefit significantly from the insight and the support of people who are data experts and understand the privacy dimension. Let me give you what to me is the sort of most graphic example of this briefly. I animated a real campaign last year, perhaps the year before, against the Google Fitbit merger. I was very unhappy about that merger going forward. And I dispute somehow the reading that this was a merger in which the data piece was really vetted and looked at in depth. I'm not disputing the fact that the Commission thinks that they did, but the concern that people had outside was not simply the possibility that the health and fitness data of Fitbit was going to be used for digital advertising. Google is super dominant in digital advertising. The Fitbit data wasn't going to matter that much. What we were concerned about is the potential for the extension of, in the use of that data to other domains, combining it with data on location, intent, purchase, shopping, search, and then being able to identify and discriminate people in terms of the medical history, in terms of the health insurance, in terms of employment. It is this kind of potentially dystopian implication that I think, and we thought, a number of us thought, needed to be taken into account, not just digital advertising, but enough as that is.
And that's something that the Commission didn't look at.
The Commission eventually adopted a remedy that was essentially to say the data cannot be used for digital advertising purposes. Who cares? I mean, that is not going to be increasing the market power of Google in any shape or form. The real issue is the potential for extending the power in other adjacent domains through targeted offers in ways that we object to.
So the under-enforcement of the competition rules can give rise to situations that are prone to big abuses of privacy. Olivier, the FTC has brought a case that actually leans both on privacy and competition rules against Facebook, I think. Can you maybe give us a flavor of it?
Yeah, I can give a flavor of it because there are public filings and people can always take a look. It's not a case I'm working on, but I think it's a case that we are excited about. Before I start, I want to also, as Cristina, thank the folks, the organizers, for inviting me. It's actually a thrill to be in person at this event. And I also want to make a high-level observation that is not that picks up on the point that Cristina made before I talk about the Facebook case, and that is that part of the problem, I believe, to the extent there is a problem, is that we, in law at least, compartmentalize a lot of different areas. In this case, we're talking about competition and data protection, but we may not have, we need to evolve the existing categories that exist to apply to phenomena that are pretty new. And I very much like your account of how monopoly is developed pursuant to ignoring or flouting existing data protection laws. But these companies and a variety of companies are also flouting other areas of law. I think of discrimination law as well. And these are all areas that are compartmentalized. You can go to a civil rights conference and not see data protection people. And you can go to a data protection conference and not see competition people.
That's true.
And this is a feature of the compartmentalization in law and whether or not it's addressed to our current phenomena, in my view. But with regards to the Facebook versus FTC case, so now Meta, there was an original case filed at the end of 2020 that Facebook moved to dismiss and succeeded because, according to the district court opinion, the FTC's prior complaint did not sufficiently allege a market definition and market power, among other things. Under the new chair, and pursuant to the invitation from the district court, the commission, pursuant to the chair's request also, the commission filed an amended complaint that was upheld earlier this year, and we're very happy about it. Now, but the reason that this is why you're asking me about this, Nicholas, is it's a specific instance that does very much what we've heard Cristina say, but it's in a different setting. And by the way, I'm mindful that what's happening in the US is different from the kind of questions you all are having here. We have something more like a singular regulator in the FTC. But the allegations in the complaint are competition allegations. They're about the market power and monopolization. But the data protection concerns, or commercial surveillance concerns, are the ones that animate the account for how the power was acquired in the first instance. And so the general argument is, and by the way, this still needs to be tested as a matter of proof. This is just at the matter of, at the level of allegation, the court has allowed the case to proceed. That is, that the allegation is that Facebook, I'll just use Facebook, even though Meta is the company now. Facebook was harnessing the power of third-party developers, application developers, and there were some opportunities that they saw, but that third-party developers also saw because of the user base that Facebook had. With better applications and third-party developers in partnership using the API that Facebook made available, that brought in more users. But the reason this is so important is because in the absence of a significant comprehensive data protection statute or regulation in the United States, Facebook acquired a larger user base with more developers developing applications that were attractive to consumers. And so the monopolization happens as a result of that. And then we get to the question of how they retain or maintain their monopoly by the acquisitions that Cristina mentioned. And that's the operation of the complaint. It's a competition argument, but the data protection concerns and commercial surveillance concerns are the ones that animate the way in which Facebook acquired its position in the market.
And so that also goes to the harm, I guess, that the FTC is alleging. That
well, the harm is not a data protection harm in this complaint, right? The harm is to the market, to app developers, and ultimately to consumers. I think we're going to get to this soon, but under the FTC statute, the commission is charged with protecting against unfair methods of competition and unfair and deceptive trade practices, which is understood to be consumer protection. Neither of those is data protection. And I mention that because one of the things that we are thinking about is the nature of the harm, as you ask it, in this current environment. I feel like sometimes data protection is not sufficient to talk about it. It is that data protection and the concerns associated with privacy are certainly relevant, but we've been talking more about commercial surveillance as a business model that helps to engender market power. And this is, I mentioned the Unfair and Deceptive Trade Practices Authority because in some ways that's consumer protection concern is a little bit broader than just data protection, but also in the way that the chair has been talking about it, similar to antitrust and market concerns.
So moving over to Australia, Angelene, I think in Australia, the government's recognized that there is this important overlap between what can be privacy rights and data rights and competition law, because it's introduced a data portability right into the country's antitrust laws. Could you tell us a bit about that? And also who enforces it if it's neither privacy law, neither competition law?
Well, thanks, Nicholas, and it's great to be here. I'm joining you from Sydney on the traditional lands of the Gadigal people of the Aurora Nation in Australia. And what a marvellous topic that's been discussed today, and it really goes to the centre of something that I'm deeply committed about, and that is the intersection between consumer competition and data protection law. And I agree wholeheartedly with Cristina that the perspective of data protection practitioners needs to be taken into account in regulatory action involving consumer competition and the handling of data and markets with data-driven business models. And also with Olivier's point around the need to break down compartmentalisation. So Australia, I think, has a very good example of looking at consistency, collaboration and convergence between data protection and consumer competition laws. We have a data portability right. Unlike the GDPR, it's not located in the privacy law. It's located in our consumer competition law. It's called a consumer data right, and it is a competition lever aimed at unlocking the value of data. It's also aimed at putting individuals in control of the handling of their personal information. So it's a very good example of a reform that seeks to both impact markets, but in a privacy protective way. In order to participate in the system, it started in the banking area, and banks have to be accredited in terms of their security to participate. Information with consent can be sent through to a third-party intermediary who can assess your data and assist you to get a better deal and to then port your data to another bank. But it's not limited to banking. It's being rolled out in telecommunications and the energy sector, and it's intended to be economy-wide. In terms of enforcement, this is, I think, the interesting aspect of intersection. So our competition and consumer regulator is responsible for enforcing those aspects of the consumer data right. My office is responsible for enforcing privacy safeguards. So privacy principles are replicated and, in fact, enhanced and built upon in the consumer competition law. And this way brings together both that market impact, the ability to unlock data to allow fintechs and others to enter the market where there's been a monopolisation, but at the same time to ensure that individuals are put at the centre of controlling the handling of their personal information for their own benefit. Thanks, Nicholas.
Excellent. So that's a concrete example of regulators from one sphere working hand in hand with regulators from another sphere. Alexandre, how you who know much more about such examples in Europe, how does this compare with what happened with the digital clearinghouse, for example, or what else is happening in Europe?
Yes, so also thank you very much for the organizer for inviting me.
Alexandre, I think they just need to turn the sound up for your. Oh, we can't hear you at the moment.
We have to read your lips.
No, which is not easy. And is it better like that?
Let's try again.
Is it better like that?
No.
Yes, like that.
Let's Alexandre, we'll come back to you in just a couple of minutes. Olivier, this kind of hand-in-hand cooperation exists in or ought to exist in the US, right? Because you said it's a single regulator. There are different laws under the same roof.
Right, right. So, Alexandre, are you there? No? No.
You hear me or no?
Yes.
Oh, there you are.
There you are. We can hear you.
Ah, okay. Sorry.
Vas-y.
Do you want me to after Olivier, I guess?
Alexandre, you while we've got you, you go. How does the situation that Angelene described compare with what
Yes.
we see in
So sorry for that. Huh? But so what I wanted to say is that the situation in Europe is a bit different because we have some coordination at the national level, at the member states level, and then another kind of coordination at the European level. So the situation is more complex. At the national level, I think what is interesting is the experience of the UK. No, the UK is of course not anymore in the European Union, but still it's an example close to us, which I think is very much also what Angelene has described and what is happening in Australia. And I think that's very important that the different authority discuss with each other. That's what we were trying to do at the Digital Clearing House, is just, exchange best practices and also theories, because as it was said by the previous speakers, in particular, competition authority and privacy authority come from a very different environment. One is coming more from economic regulation, the other one is coming more from fundamental right. Those communities rarely talk to each other in law, as Olivier was mentioning. So I think that was one of the effort we were trying to do. But I think if it is done at the national level, it's in a way easier because the authority share the same administrative practices, know each other a little better. People tend to move from one authority to another. Okay, I think the big challenge is then to do that at the European level. And we have now, with the Digital Market Act, a new high-level group, which is supposed to put around the same table all those network of authorities, so the network of privacy authority, the network of competition authority, the network of consumer protection authorities and others, and trying to discuss. Now, it will be extremely complicated to do, but it's indispensable, as Cristina was mentioning. So I think that is a step in the good direction. I hope it will work. Now, for the biggest platform, I think what we need is not coordination, but we need integration and centralization, and I think that's, in a way, given the fact that to coordinate different network is really not easy. I think for the biggest platform, what we need is an integrated and centralized enforcement body. And I just wanted to make 2 points here very quickly, because I heard yesterday Commissioner Renders, who was very skeptical around that, saying, we don't want to reopen the GDPR because it will take a lot of time, and we are actually extremely proud about our law. It's probably one of our best exported law. And also, he is not sure that it will help the data subject at the end. But I think on the first account, reopening the GDPR, I think you can change the enforcement system without reopening the substantive rule. It is exactly what has been done in the banking regulation 10 years ago, because we had the same problem. The big bank were badly supervised by the country of origin supervisor. Okay, and so it was decided to move it to the European Central Bank, but without changing the substantive rules. So I don't think that if you change the enforcement, you need to reopen the GDPR altogether. And the second point of is centralization, putting the enforcement further to the data subject, and therefore would not be good. Again, I'm not sure it is true, because you can still involve the national authority in the complaint mechanism, in the monitoring mechanism. Again, this is exactly what is done in banking regulation, but for the decision, I think only a European body will have the ability and the incentive to move towards the big tech. So I really think that, there is two debates here. There is the debate of coordination and exchanging of best practices, but also the debate of integration and centralization, you see. And I think that's the difficulty of Europe, is that very often the two debate, we have to see the two debate together.
Thank you very much, Alexandre. Olivier, presumably that debate, you don't have it in the FTC, or you would aspire not to have it in the FTC because it's under a single roof.
Right. I think the best is to say that at least the chair and many of us aspire to have a fully integrated approach. And I want to underscore and maybe ask a follow-up, but I'll answer my question, but it's addressed to Alexandre. And that is, by integration, you can have integration. I don't know. I actually don't know what exactly that could mean. It could mean integration as to internal to competition law, in furtherance of what Louis Brandeis argued is, you need a large entity. If you're going to go after big tech or big oil or the trusts, you need a big entity. And you can just do that as the competition policy. But I think you also mean integration in the sense of the theme of this panel discussion, and that is data protection and competition, which is a different kind of integration, and opens up a whole can of worms as well. With regards to the FTC, so it is a single regulator, and that ostensibly creates a clear impression that the Commission has the capacity and at this moment, the desire to see a fully integrated approach to commercial practices. And the challenge is as much an institutional and legal one, because the Competition Authority and the Consumer Protection Authority are set out separately under different bureaus within the Federal Trade Commission. And they have collaborated here and there, but that collaboration is, you all are DPAs, and you know that there are institutional commitments that bureaus and divisions within agencies have, and that's a difficulty that the Commission I think aspires to reach beyond. But that's there's internal to the Commission. There's that. We also have different legal authorities as to both. For example, with regards to policymaking, rulemaking, it is harder to promulgate policy with regards to consumer protection as what you call a procedural matter, whereas competition law does not. The Competition Authority does not present the same sort of procedural limits, and those are set out by Congress. So we do have those separated out. But one of the things that Chair Khan has been talking about is integrating these two. And I think one of the interesting ways that we've seen this happen is by building out, with regards to big tech, in particular online tech companies, is the integration of technologists into the enforcement, investigations, and the development of policy. Because so you've got even internal to the FTC, you've got your relative separated institutional commitments, but with a more evolved, more developed, more integrated technologist expertise, we can turn to remedies rather than the legal authorities as such, right? And that's one way that it's still work that has to happen, but that's an institutional way of breaking out of the dualism that we see. What do technologists bring? They bring a sophistication with regards to specific remedies that are particular. The Commission, for example, has been thinking about algorithmic disgorgement or algorithmic deletion. Has brought actions in that regard. That's the sort of thing that we want smart technologists engaged in discussion about. But anyway, so maybe that's for the institutional problem. Maybe what you need is an institutional solution.
Right. Angelene, in Australia, there is no common umbrella overseeing the different agencies, but you do have a level of cooperation that's modelled, I think, on the approach in the UK. How does that work?
So in Australia, as you said, we have separate institutional arrangements for consumer competition law, for data privacy law. We also have an e-safety regulator that's aimed at preventing online harm, particularly serious online abuse. And we have a telecommunications regulator. And I see as imperative as regulators that we must act in the public interest, and that we must act in a way that's seeking to reduce consumer harm and to pull whatever levers are necessary to achieve that objective. And when you are regulating digital platforms that are bigger than nation states, it does take a network of regulators, both domestically and internationally, to address the myriad of consumer harms that can arise. And no one legal framework has the answer to both prevent and rectify those consumer harms. So in Australia, we have developed a digital platform regulators forum. It's in its early days, but it does bring together all of those regulators that I just mentioned. And our purpose is to have the consistency in regulation, to collaborate, to ensure that we are being coherent in the way that we're regulating digital platforms, and also to increase our capacity. We are developing shared priorities so that we can each bring our regulatory toolkit to bear on matters of common interest. And algorithms is a good example of that, where you have the competition concerns around algorithms and preferences. You've got data protection concerns around the use of personal information to cause privacy harm. You've got e-safety concerns around increasing serious feeds that are being provided to people, resulting in online harm to individuals and children. And central to that is this issue not only of information sharing, but also looking at joined up regulatory outcomes into the future. And part of that is ensuring that we have the right capability in regulating this complex environment. Olivier raised the issue of technologists. That's one of the issues as contemporary regulators, that we need to have access to the level of expertise that could mean that we are able to identify emerging harms to consumers and to take action to prevent those harms manifesting. Thank you.
So regulators in Australia, they're conscious that they have a toolkit of different tools that they can use to intervene in the digital sector. They want to ensure that they're consistent and they're not pulling in different directions. And they want to take the best decision about what lever to use. Cristina, you who go in to see regulators in Europe, privacy regulators, antitrust regulators, do you get the feeling that there is this common vision? Are they talking to each other? Do they understand what the tools of each other are?
I want to go back to a couple of things that both Olivier and Alexandre said. Alexandre is rightly pointing to the need for cooperation, at the same time integration. I've certainly emphasized the integration piece because I think that there is a desperate need for incorporating the competencies of data protection, which goes in the direction that Olivier also mentioned. It may mean also to expand the technologist group inside the competition agencies. What is missing in antitrust now is the faintest idea about how data work and how technology works. This is why enforcement is taking forever and goes nowhere, because no one has the faintest idea what's going on behind the, under the hood at antitrust agencies. So I was yesterday at the CMA conference in London, which was interesting because he was describing the way in which that agency has developed technology capabilities. Those technology capabilities, data capabilities, are also the capabilities that many in the data privacy community have, and that's the sense in which these things need to integrate. So Johnny Ryan and I wrote a paper last year, which was about how the antitrust orthodoxy is blind to this kind of stuff still. So my answer to your question is no, this is happening in part. I mean, there are patches. I mean, Australia is one, the UK is one, France is one, but it isn't happening systematically. Can I also single out briefly my own profession as being particularly unhelpful in this space? The economists in this area are a waste of space, total waste of space. Somebody said throw them at sea. I couldn't agree more, because the reality is that the way in which we study traditional economics is that we're taught that the best outcome is perfect information, right? So anything that is somewhat asymmetric information, imperfect information, isn't very good. When you move towards better, more perfect information, then you produce products that are better, they're richer, consumers get what they want. So the posture of economists generally is more data, better, fabulous. The upside of more data is that you're going to get more targeted products. What's not to love? So when I was discussing the Google Fitbit case, in front of a group of economists, the answer tends to be, what are you talking about? More targeted products to individual consumer? This is wonderful. Why shouldn't that be wonderful? So there is a real total need to either ignore the economists in this space or educate them in this space. I'm not quite sure what is which, but the general posture, which does not help, because economists are very influential in the antitrust debate still, to take the view that this stuff really needs to be integrated, incorporated, and a different vision needs to be put forward. Unless we take these theories of harm seriously around exploitation, around the way in which consumer surplus is being extracted in ways that, if it's done by a monopolist, is not pro-competitive, we are not advancing the cause. So I think that one of the things that needs to happen is also that economists grow out of their shell or just go fishing, and don't really interfere with this stuff.
So I love this provocation.
Please.
I think Cristina doesn't
Be our
mean it as
guest.
provocation. She actually means it in earnest.
I mean it.
And it's for the purposes of the debates we're having today, a very important point. I'm not prepared to say that we get rid of all the economists. I'm not sure you are either.
Yeah, I'm provoking.
Because this is in some ways a question of what are the prevailing standards that are governing the way in which economists are doing this. And there is an emergent view, even among economists, about evaluating what is harm in the context of data protection, kind of qualitative, what Europeans call dignitary harms, and that are measurable, right? So, and we do need econometricians to help sort that out. But I very much like this point, because it also speaks to why sometimes the vocabulary we have, right? We have the consumer protection, data protection, and then competition vocabulary is not sufficiently adapted to the phenomena that we are seeing and that we've been calling commercial surveillance. And an example is this, you were talking about how many economists have intimated that perfect information is the ideal way, that perfect targeting is the ideal way to move forward. But it's the nature of the relationship that consumers have with these companies that seems extractive, and often.
Yes.
And one of the things that Chair Khan has spoken recently about is these kind of take it or leave it arrangements for high stakes services. Now, is that data protection? Is that competition?
Exactly. What is it?
It's
But it matters.
and I think we need a vocabulary for it to measure what the harm is, and that's why I do think econometricians do help. They can help if they are thinking in this way.
Alexandre, Angelene, would you? How do you rely on economists in your enforcement activities?
Well, I think expert evidence is always required around economic impact and economic harm. But I think, from my perspective, the kind of technical experience as a regulator really rests around the technologists. And an issue that's been recently canvassed in Australia, our Australian National University has conducted a study around whether or not there ought to be one regulator for tech. And their study was based on interviews with regulators like myself, and the unanimous view of regulators in Australia was that we shouldn't have one regulator, but rather we need, as regulators, to have access to the technical capability that allows us to match these giant tech companies. And we can see in the UK that there's been some moves towards that, with having a particular entity that then provides that technological advice. And the other aspect in Australia that's of interest, I think, is that this study is consulting on a model which is more about having some governance and arrangements across regulators, and also brings in representatives from industry, from government, to ensure a cohesive regulatory policy right across the Australian economy.
That's interesting, the idea of this kind of mismatch between regulators on the one hand and the giant companies that they're meant to be regulating. Alexandre, isn't this something that we see in Europe, in particular in the field of privacy?
Yes, I wanted just to react also on what has been said, because I think economists have been very instrumental in the past as a kind of a platform of integration, and because that's what we are discussing across different fields of economic law, competition law, economic regulation, and so on. And I think, this new role of integration, and I think that's what Olivier was hinting at, and I think it's extremely interesting, is that technologists could play that role for tech law, that they are kind of a platform of integration for different fields of tech law, like data protection, consumer protection, and antitrust. Okay, so I think that's the same movement that we saw with the economy some years ago for economic regulation, we can hear for tech law. The second thing is I wanted to say is, of course, economy is not a monolithic science, and so you have different type of economists. What I really don't think that we should get rid of them, because they are extremely interested and expert in understanding incentive. So maybe you have some economists who don't understand tech, but at least they understand incentives. And I think sometimes when I discuss with my privacy friend, they I think understand less the incentive than the economists. So I would not sure that getting them over would be the solution. But it's clear that they need to adapt to the new reality, and they need to think their incentive and cause and effect in a new context.
Right. I think, Christine, what you're saying is that it's not just the integrate. It's not just that the regulators need to speak to one another, but the whole ecosystem has to be there that can understand what the issues are and how they overlap.
Just to be clear, I'm not suggesting that economists are just complete waste of space in every form. The point is that there are, of course, different types of economists. There is a very narrow church, which is the industrial organization economist, that dominates the field of antitrust. And this is a narrow church, which is very unwilling to go and broaden the tent, because we got a narrow canon of models and things that we've done for 20 years, following the Chicago school. Now we've evolved a little bit, but we're still kind of there. And this group is reluctant to accept that there is a way of thinking about this that is possibly also economic. Economists think in terms of trade-off. And so if you tell them something is a fundamental value, they switch off. I don't care. I cannot trade off something which is a fundamental value against anything else. I need a benefit and a cost. And these two things need to somehow be traded off against each other. And so in this sense, the discussion is a bit, pointless. In fact, they don't get involved because they don't see it as their domain. So that's my point. And sorry, Alexander, the only reason I mention it, of course, because I hail from that community, and it seems to me that it is a missed opportunity for that community not to militate in favor of this integration much more vocally, much more actively. What else are we doing? Doing models in an ivory tower? Talk about vertical arithmetic? Who cares?
So, this is a fascinating and I think important conversation with talking about how to instrumentalize integration. And part of what I believe, Cristina, you're talking about is ideology and the prevailing conventions that have governed even how our law is articulated. I do want to say in the context of data protection, Acquisti, Alexandre Acquisti,
yes,
is an economist, right? Yes. And a very good one who's alert to more than trade-offs, but kind of trade-offs to be sure, but behavioral phenomena that is helpful for thinking about harm in areas that have not really, that we need more research in. So I think we can champion the work that is happening now, yes, even among economists, and yes, some, and that this is evolving.
And Alexandre, do you think that, I see you got your hand up as well. Do you think that this, do you think that the models that we see emerging, say, from the Digital Markets Act in Europe, or these developments in terms of cooperation, is that going to enable this kind of joined up thinking?
Two things, yes. So first, trade-offs are everywhere, also in human rights. So I don't think that we could say that when we speak about human rights, there is no trade-off. I mean, there is trade-off between human rights. And I think it's very clear, for instance, on the new proposal that the Commission has done on sexual abuse content, child sexual abuse content. I mean, there is clearly a trade-off between security and the protection of the child and privacy. So, I mean, trade-offs are everywhere, and that's why I think the expertise of the economist, good economist and open economist, I agree, I think are extremely useful. Now, on the DSA and the DMA, yes, I think it goes in a very right direction for two reasons. One is that it is pushing this conversation of different authority with this, in particular, the DMA with the high-level group, which, as we have discussed before, will put all those authorities across the table. And hopefully, they will start by discussing the DMA implementation, but hopefully it will go much beyond that, and it will discuss a lot of other things. And the GDPR. I was also interested by what Angelene was saying, that in Australia, you have the portability right, which is enforced by the consumer and antitrust authority, but then the privacy safeguards are enforcing the GDPR. This is not the model we have in the DMA, because in the DMA, you have some, let's say, GDPR safeguard, but I guess that they will have to be applied by the Commission, not by, and we don't have a kind of European privacy regulatory authority. So there the model is a little bit different. But it will help the conversation, hopefully beyond the DMA. And the other thing I like is that it goes towards centralization, because that's the other part of the debate. We have the debate of coordination and integration, and then centralization. It goes for centralization for the big tech, and I think that's the right approach.
Thank you very much. I guess there's another type of cooperation that we haven't really discussed, which is international cooperation. And obviously, that comes up in the European context within the EU, but it's also possible for regulators to cooperate across borders or between even continents. Is that perhaps, can that help address some of these issues? Yeah, and I guess sort of a bonus question on that, the size of the big tech companies, the scale, the conversation we've had now about needing to have under the same roof different, or needing to be able to rely on different levers and being able to rely on technologists and economists that are pulling in the same direction. Doesn't all of that argue in favor of the ideal situation being having a single regulator that can apply all of these laws to companies, perhaps just in the biggest cases. Angelene, what's your view on international cooperation and the idea of just a single tech regulator?
Yeah, in terms of a single tech regulator, as I said, the Australian position at present, in terms of the views of the main regulators, is that working together in the public interest in a cooperative and collective way is the preferable solution. Yeah, I can see that there can be conversations, and the future might institutionally mean a more institutionalised approach to that. But I think we can't lose sight of the need for separate data protection law, separate consumer competition law. They're each, whilst they've got areas of intersection, they have different policy and social objectives. And the prevention of privacy harms, as we've talked about, part of that is around the protection of a fundamental human right, about proportionality being reasonable and necessary. And it goes to harms for individuals that are not only economic in nature, but it's around our right to autonomy, the impact, hurt, humiliation when our information is used in ways that we don't expect or misused. In terms of international cooperation, as I said earlier, in terms of it taking a network of regulators domestically and internationally, that connection needs to be international connection between data protection regulators, but also consumer competition regulators. I sit on the executive committee of the Global Data Protection Forum, the GPA, and one of our key objectives is to have consistently high standards of protection globally. We have a digital citizen and consumer working group, which is about increasing the intersection between our regulatory remits. We are mapping all of the regulatory actions that are happening globally that draw out both data protection and consumer competition protection. And it's that first step of raising awareness and then collaboration and integration, which is, I think, the direction of travel that we're headed in.
Right. The idea being that the companies that regulators across the globe are grappling with are so large that there needs to be some pooling of resources and some teaming up. Would anyone else like to chime in on the idea of, do we just ultimately need to move to a single regulator, a single digital regulator that can deal the cards as it sees fit?
A single global regulator? Is that what you're asking?
Probably I think more at the national level.
You have that.
Yeah, we have that effectively. I mean, in terms of international cooperation, though, just to piggyback here and be specific, and to echo a point you've been making, even though you're not a discuss it, but you've made it a couple of times very usefully, Nick, and that is the different levers that are available to different DPAs across the world even. And one opportunity might be in the different investigatory tools that the legal authorities, they have allowed them to use. And that, in terms of enforcement, I believe the FTC is eager to engage in that kind of collaboration.
No, we're nowhere near that in Europe, of course, because we have this crazy institutional design in which the DPAs are sort of many, and then you have the competition authorities that are the commission, and then at the national level. My hope, I don't see the possibility of a single digital regulator kind of emerging. My hope, however, and I think what we actually need to do, is to design a framework in which the views of the data protection experts are systematically incorporated in antitrust cases. We want an official, public, available opinion from the data protection experts in every single case. Why aren't they consulted systematically? Why aren't they heard? Then it goes in the mix. And that opinion is public. And so people can see it. And one cannot hide behind a chair and say, well, I talked to them and they are on our page. No, let's see what they have to say. Write it down, make it public. And that is what needs to happen.
Very good. We have a few minutes left. We have time for questions if If there are several. Shall we do a round robin and then we'll just do a last round of the panel?
Yes.
How much time do we have?
I'm sure.
We have another 8 minutes, so 10 minutes. Yes,
Okay,
please, the lady here in the front.
Hello, I'm Nathalie Lanray. I worked for a French company called Criteo. I would have 2 questions, very brief. We've talked about the fact that some economists are not tech-savvy anymore. My question is, what about ensuring that data protection authority understand better the market they are regulating, and that they have an obligation, for instance, to do an economic assessment of the effects of their decisions, just as the UK data strategy is currently proposing. And my second question, which is actually something we have not really discussed about, is how to deal with unilateral decision of big players that are taken under the excuse of privacy and that create distortion of competition. And we've seen a number of cases at the European level and in several EU countries following the Apple ATT decision and the Google phasing out of third-party cookies. Thank you.
Super.
Johnny behind you.
I think there's a couple of, we'll try and give everyone a chance, and then, but so let's rattle through.
Brief question, but first a suggestion. Rather than supervisory authorities having to do a market assessment, it'd be really good if supervisory authorities could understand companies like Criteo and other ad tech companies. The question is for Alexandre. What is the status of the digital clearinghouse at the moment? As far as I can see, it's been lying fallow for 3 or 4 years. I don't know, but it looks like that. Is there, post-COVID, might there be something happening there again?
The gentleman just behind.
Hi, Gianclaudio Malgieri, Brussels Privacy Hub. 2 small points. One, you know, competition law has getting also policy goals, the new Brandeis movement in the US and here with maybe the German Bundeskartellamt, etc. And in Europe, we already have environmental issues that are a bit embedded in a way, at least in the Vestager's statements, in the discussion of antitrust law. So why can't we do the same with data protection? Why there's much more skepticism about that? The second point about the all or nothing point that Olivier was making, if it is data protection, if it is competition law, etc. Can't we say that it's exactly the combination of the two? Because we need the competition to define the dangerous power, and we need data protection to define the harmfulness for people. And so the all or nothing has a scope in competition law, but the harmfulness in data protection, I don't know. This is a bit an academic and nerd point, but maybe your opinion would be great.
There's somebody behind you.
Hi, my name is Jordan Nagel. I'm from the Australian Department of Home Affairs. My question is to everyone in the room more generally. Is there a space for a set of principles that we should be looking to establish for common liberal democracies? What are the things that we believe in terms of regulation in this space? So rather than a clear set of rules per se, but a set of principles that we can all draw on to coordinate our approach at that level.
There's a question here in the front and then one at the back.
You'll ask all these questions.
You are taking notes and then you're going to allocate them.
I think we'll go. You pick which one you want to address, and
They're all great questions.
Michael Veal from UCL. When we're talking about trading off between different policy issues and thinking about that, my question is about who defines that space that the trade-off is carried upon. At the moment, we have a situation where the space between, say, privacy and competition is often defined either by large platforms that really say we can't do privacy without us orchestrating everything in a very centralized way, or companies like Criteo who say we can't do privacy without a largely illegal business model of free-flowing data, which is largely unaccountable. In terms of working regulators to work together, I'm wondering who creates the vision for a third way here, often which has a mix of pluralism and privacy, and what's the capacity needed and how would we achieve it? Say, maybe this is a false dichotomy. Perhaps there are ways to have pluralism and privacy in technological ways and social ways without buying into either of those different dimensions. And where does that idea come from, given that there's not really very much money pushing that particular path?
Excellent question.
And one last one at the back.
Thank you very much. Rob van Eyck, Future Privacy Forum. I have a similar question, but I'm going to rephrase it differently. If I look at the CMA decision, it's based on that the data and metadata needs to continue to flow, because otherwise it would create a market disturbance. This seems very orthogonal to the privacy by design principles of data minimization. So the real question is there any way how we can overcome this, the difficulties of the two contradicting requirements?
All right, I think I noted most of all of them done. So yeah, this question about do data protection authorities need to do more economics? There's several questions about the sort of situation that arises with Apple's ATT changes, which is bolstering privacy, but potentially harming competition. How to make the trade-off there. There was a question about the digital clearinghouse. There was how data protection authorities should assess harm, and then whether we ought to not just be talking about cooperation globally, but perhaps shared principles. We've got maximum 10 minutes left, a couple of minutes each at most. I suggest we start with Alexandre, because there was the most direct question about the digital clearinghouse was addressed to him. Alexandre, if you're...
Yes, thank you. So the Digital Clearinghouse has been a project which was started by the EDPS, then it was organized by the University of Tilburg and my university for 2 years. But now, this part of the project is finished. And so the big question and this conference is help to feed the reflection of what we do next, And I see two parallel possibility. One is an institutional one, and I think the DMA high-level group is a form of digital clearinghouse, but limited to the European Union, because the digital clearinghouse was more open and was beyond Europe. And then another track, which could be more an academic track, where some universities or some academics and some are already active, continue to develop this reflection. So I think the form that it has so far will have to evolve into two different tracks, because that was one of the difficulty of the digital clearinghouse in its previous form, is that it was something in between institutional and academics, and so this is why it has some of those weaknesses. I wanted to react maybe on two extremely interesting and fundamental questions which were raised. Who defined the principle, and who defined let's say the space where the trade-offs are organized? And I think it is of course important that it is the public power and the democratic elected public power who decide both. Now the question is whether they are able to do that and how. And I think regarding the space, I think I read at least all the initiatives that the Commission is doing now, is putting on the table, the DSA, the DMA, the Data Act and everything, as really trying to push for more disintermediation or decentralization of the cyberspace, in the sense that you really want to help the intermediaries to enter in the market, to enter in the space. Now, whether it will work or not, that's a question mark. Whether you can achieve that only with regulation, or whether you need more, you need a kind of more assertive industrial policy. I would tend to think that we need a more assertive industrial policy. And the problem is that Europe is very good at doing regulation, but is not very experimented at restructuring a space, or helping to nudge the market to go to another space. And I think that's really the big question of the future.
Excellent. Thank you very much, Alexandre. Angelene, would you like to pick up on any of those questions?
I think it was a really interesting comment around data protection authorities paying regard to economic impact. That, of course, has to be central. The free flow of personal information is part of the objectives that I have to balance in taking evidence-based and proportionate regulatory action, and the economic impact has to form part of that assessment. The issue around the intersection, sometimes called trade-offs between protecting privacy and competition, I think just takes us full circle back to the start of this conversation, which is that the perspective of data protection has to inform competition actions, because competition actions can have an impact on data protection rights and vice versa. And in terms of issues of common principle, I would go back to the central proposition as to what we seek to address. And I think the common principle is that the handling of personal information and consumer competition needs to ensure that we minimise harm to individuals. And sometimes that's also about minimising harm to the public interest, and that can also be economic markets. So it's all one continuum, but all of the dimensions of those perspectives needs to be brought to bear in terms of the regulatory action that's taken by both data protection and consumer competition. And finally, I'd say in looking to the future that we need to look more carefully at legislative requirements that place positive obligations, ex ante obligations on entities, so that we're not regulating after the harm has occurred. In the same way as for health and safety law, you have a positive duty to minimise the risks of harm in the workplace. We need that kind of thinking to be elevated in both data protection and I think consumer protection law. Thank you.
Thank you very much. That's interesting. That kind of ex ante thinking is what I think Europe is trying to do with the Digital Markets Act. Olivier?
No, he goes and then I'll finish.
Yeah.
Olivier, over to you.
We made an arrangement. I wanted to, all these questions are quite excellent. And I just want to take up the first one about regulatory impacts. And if maybe we lost that message in our conversation about the utility of economics, maybe we did. But in the United States, for ex ante policy making, we have to, as a matter of course, issue regulatory impact statements. So it's not just companies that have to issue their impact assessments, but to survive scrutiny, judicial scrutiny, which gets me to another point that has come up in a couple questions. The agencies across the board have to justify, pursuant to conventions and economics, whether the regulatory intervention is appropriate. There were a handful of related questions about. One is the institution, the example of the take it or leave it arrangement, take it or leave it phenomenon, how it doesn't fit cleanly in my view, in either competition or consumer protection, but that they are clearly in conversation with each other. The problem here is that, of course, we can be creative as enforcers on how to do this, but the other institutional player in the United States, and evidently in Europe as well, are the courts. And you can't just make it up, right? You have to be able to, as lawyers, as regulators, we have to do this carefully. And so, and that matters with regards to the conversation about a couple other questions here. So whether we like it or not, these are the conventions we have, and we have to be creative about it, but only as creative enough that the courts would be willing to accept them.
Cristina, you have a final.
So I wanted to pick up in particular on Michael's question because I think it's an excellent point. I mean, I think you're absolutely spot on. We are on the one hand uncomfortable with this world in which we have giant tech companies which are bigger than countries, setting standards for the rest of the world and asking us to believe that they're benign. Trust us, we believe in privacy. This is a value we hold fundamentally. I trust you, but at the same time, we have also a world in which competitors are exploiting, using the system to make complaints that are equally commercially self-interested. And I'm not making judgment on anybody, but there is a big stream of cases on self-preferencing that I don't know the merits of. And I don't think anyone, in principle, that could be self-preferencing, I just don't know yet. And so how are we going to actually wade through this is the question. I mean, newsflash, I don't have an answer. But I also worry about a situation in which a single competition authority needs to decide on a single case, on a single complaint brought by company X, and then that becomes somewhat the precedent that holds for the rest of time, made at one particular point in time because of a complaint by, I don't know, Criteo or somebody else. I mean, I don't think that's the way forward. we need to think more deeply about how we make these trade-offs between companies that are as large as states and they are setting the rules, and others that are saying, but I've got a different view and what you're doing doesn't actually help me, so I'm going to say that you're self-preferencing. Where are we? I don't know the answer, but you're absolutely right. That's the question.
Well put. All right. Well, I think there's nothing more for me to do other than to thank our panelists.
Thank you, Nick. Thank you.
Thank you.
And thank everyone for attending.